Hello everybody, thanks for joining me today in sunny city of Manchester today. Today's Omid is Bava Kamma 78, so let's go. So following on from the last Omid, in a similar way, Vina said, if Rabbi Yochanan had not said that the pious one and Rabbi Dosa said the same thing, I would say, who is the Tana who taught the opinion of the pious ones? It's Rabbi Dosa. I would have said so that an uninterpreted Mishnah should not present a difficulty to the opinion of Rabbi Yochanan. And the reason why this would have resolved the difficulty of Rabbi Yochanan did not say to apply this principle, that the halacha is always according to an unattributed Mishnah. In a case where the Mishnah expresses the opinion of an individual sage, according to this interpretation, Rabbi Yochanan does not rule in accordance with the Mishnah, due to the fact that it represents the opinion of an individual sage, Rabbi Dosa. Rather, he follows the majority opinion. Yet now that Rabbi Yochanan said that the pious ones and Rabbi Dosa said the same thing, it cannot be claimed that they are one and the same sage. Consequently, the ruling of the Mishnah is evidently accepted by these two sages, and therefore the difficulty from the Mishnah cannot be resolved by assigning it to a single sage. The sage of Nahodea is explained in Treatise Sanhedrin 17b that this anonymous attribution is referring to Bava Kamma, and it may be assumed that this is the meaning here as well. A fourth generation Amor in Babylonia, Rabbi Kamma apparently lived a long life, as he is depicted as engaging in discussions with the sages of previous generations. Since he was the head of the yeshiva nowadays for over 20 years, some have had halachot or cited as the opinion of the sage nowadays without further identification. Say, one cannot write a document of authorization, an orachta, document of authorization. In most sources, the word is, as it appears here, orachta, and this is the version favored by Rabbeinu Tam and the Seif HaYosher. It refers to a document through which one gives permission to another party to take action pertaining to the principal's property. Some sources have instead the word adrachta. This document, also known as hadafa, entails one to pursue lirdaf and seize money owed to him. It is a legal document drafted by the court, authorizing a creditor to locate and take possession of any property belonging to a debtor in repayment of the debt, to assign another to collect the debt or deposit of movable property on his behalf. Rav Ashi said to Amaimo, what was the reason for this halacha? Amaimo said to him, it's due to a principle stated by Rabbi Yochanan. As Rabbi Yochanan says, if one stole an item and the owners have not yet despaired of recovering it, neither of them is able to consecrate it. This, the thief cannot consecrate the item because it does not belong to him, and that one the owner cannot consecrate it because it is not in his possession. The granting of authority to collect the debt involves a transfer of ownership of the item or money from the owner to the collector. Otherwise, the debtor could refuse to convey it to the collector. In the case of movable property, as it is being held by another, it is not in possession of the owner. Just as the owner cannot consecrate this item, he cannot transfer ownership of it. There are those who state a different version of this halacha. The sage of Nahodea say, one cannot write a document of authorization for the collection of movable property that the bailey or debtor has denied owing. Amital today the chafrei, for the collection of movable property that the bailey or debtor has denied owing. The reason an authorization cannot be issued in this case is that the ownership of the item to be collected is in dispute, and therefore a document attesting to the transfer of ownership from the purported owner to the one collecting the item has the appearance of falsehood. According to this version, the statement of the sage of Nahodea is unrelated to Rabbi Yochanan's halacha, and consequently may authorize another in writing to collect an item, as Rabbi Yochanan ruling about an item not in one's possession was issued only in regard to consecration, for which there is a direct basis in the Torah for the requirement that the one consecrated item must possess it, so the Rashba. According to other earlier commentaries, Rabbi Yochanan's halacha that applies to other forms of transfer of ownership, including the case of selling an item that one owns but is not in his possession. If one claims that he owes movable property or money that is currently in the possession of another, and the latter denies that he owes it to him, the claimant may not write a document of authorization to enable a third party to collect the item, because the document has the appearance of falsehood. This ruling is in accordance with the second version of the statement of the sage of Nahadiyah, following the principle that the halacha is generally in accordance with the statement of Bava Kamma. Later, the Gaonim instituted that an authorization may be issued to collect the debt, even if the party who supposedly owes the money has denied the claim. This applies only with regard to debts recorded in a promissory note, not for loans by all agreement. Others maintain that one may issue an authorization to collect loans by all agreement, even the payment has denied owing the money, as they claim that the concept of appearance of falsehood does not apply in this case. Sefer Kinyan 123:1. The Gemara infers, according to this version, the only reason the document cannot be written is that the bailey or debtor has denied owing the item, as the document written under these circumstances has appeared as falsehood. This concept is mentioned several times in the Torah. According to this principle, a document may not be written or unsigned by witnesses if it's not accurate at the time, even if it becomes correct at a later date. It should be noted that in several places the Gemara rejects this principle. See Seif HaYasha. Since the purported owner is transferring ownership of an item over which his ownership is in doubt, but it can be inferred that if the bailey or debtor did not deny owing the item, one can write a document of authorization, and the sage of Nahadiyah state another law with regard to this kind of document. A document of authorization in which it is not written, go and take legal action against so-and-so, and take possession of the owed property. If one has real estate entrusted to another, or if he has movable property that another is safeguarding and he wishes to appoint an agent to take legal action and remove the property from the holder's possession, he may write a document of authorization that the agent can do so. The document must contain a clause in which the owner transfers ownership of the property in question to the agent and says to him take legal action to take possession of the property and remove it from his possession for yourself. If the owner does not write this, the party holding the item in question can say to the agent that he is unwilling to engage in legal proceedings with him or any other person than the owner of the item. Rabbi Sefer Kinyan 22:4. And collect it from him for yourself has no substance. It's not a valid document. What is the reason for this? It is because the other party who presents a document without this clause, I'm not legally answerable to you. I'm willing to deal only with the person to whom the item is owed. To avoid the situation, the authorization document must transfer actual ownership of the item to the collector, who is not claiming it for himself. Abai said, and if it is written in the document that the owner transferred ownership of only half of the item to the collector, or a third or quarter of it, this is sufficient. The reason is that since the bailey or debtor must relate to the judgment, I engage in litigation with the collector over the half. If one authorizes another to collect the third or quarter of the debt owed to him, the agent may engage in legal action of the entire sum, and according to the opinion of Abai, some say that halacha applies only if the owner of the item actually transfers ownership of the item to the collector, whereas if he merely tells him 100 dinars of that which so-and-so owes me shall be yours, the agent may engage in legal action only for the specified amount. That's in the Rama Sefer Kinyan Hilchot Shluchin V'Shutafin 3:2 and the Ravid Dan Shulchan Aruch Midbar 122:5. And collect it from him for yourself. There's no substance, i.e. it is not a valid document. What is the reason for this? Debtor can say to the collector who presents a document without this clause, I am not legally answerable to you. I am willing to deal only with the person whom the item is owed. To avoid the situation, the authorization document must transfer actual ownership of the item to the collector, who is now claiming it for himself. Abai said, and if it is written in the document that the owner transferred ownership of only half of the item to the collector, or a third or quarter of it, this is sufficient. The reason is that since a bailey or debtor must relate to the judgment, i.e. engage in litigation with the collector, only half or third or quarter of the item that has been transferred to the collector must relate to the judgment concerning all of it. And Meimar said, if the collector is empowered by authorization, seize the item, im tafas. Rashi writes two interpretations of this phrase concerning the issue of one who seizes the item from him. In the explanation he prefers for which he says to go there. It will be seizes what he collected or part of it for himself when he claims he is owed money by the one who sent him. According to Rashi's other interpretation, the Gemara is referring to the seizure of the item from the one holding it. The Gemara states that if he seizes the item against another's will, the seizure is effective. The document empowering him as collector did not state the required word and go and take legal action and take possession of the claimed property and collect from him for yourself. He collected and kept it for himself. The court does not take it away from him, as the owner transferred ownership of the item to him in a document of authorization, as explained above. Ravashi disagreed with the man and said, Ravashi said, some commentators maintain that Ravashi disagrees with the entire principle laid down by the Seder nowadays, as he holds that a collector can act as an ordinary agent on behalf of the owner of the item, rather than requiring his ownership to transfer to the collector by Hamor. Most early commentators disagree with this interpretation, claiming that Ravashi accepts the basic principle of the Seder nowadays. His disagreement is only with the opinion of Amaima, who allows the collector to seize the item for himself. Ravashi maintains, the owner wrote in the document, I accept upon myself anything that develops the result of this legal action. The collector may not seize the item for himself, as in that case he's merely acting as an ordinary agent. See Rashi Meiri. Since the owner wrote to the collector, I accept upon myself anything that develops as a result of this legal process. Most commentators understand this phrase and the word Matane to mean that the owner accepts upon himself to provide my answer, ma'aneh, that come about through the legal process of collecting the item, i.e. to engage in actual discussions in court. Others explain that the owner accepts upon himself all expenses that may be involved in the collections in the Meiri. Even if it is written in the document of authorization, go and take legal action, take possession of the item for yourself, and the owner collector performed an act of acquisition by which the owner transferred ownership of the item to the collector. This collector could do no more than an agent acting on the owner's behalf. Consequently, he may not seize any part of the item himself. Rama say for Kenyan, Yechish Nuchin Ritafin 3:1, Shochan Orchosh Mishpat 126, and the comment of the Ramah has in effect rendered the collector an agent. All the expenses incurred by the agent who received authorization for the purpose of legal action and the collection of a debt must be reimbursed by the owner, according to the formula stated in the document of authorization. Anything that you spend in this legal process shall be incumbent upon me to pay. This halacha is in accordance with the opinion of Ravashi. Even if one did not write this formulation in the document, he is obligated to reimburse the collector for all of his expenses. And as in the Rambam say for Kenna Hilchashtuchat V'Tafin 3:1 Shochan Orchosh Mitzvah 126 and the Shach there, he does not render the collector an agent to act on his behalf, and therefore the agent cannot seize the item for himself. And there is another opinion that says the owner rendered the collector a partner in the collected item, transferring ownership of half of it to him, and retaining ownership over the other half. The Gemara asks, what is the practical difference between this opinion and that of Ravashi? The Gemara answers, the difference is whether the collector has the power to seize half of the collected item for himself. If he is an agent on the owner, he cannot seize anything. If he is a partner, he can seize up to half. The Gemara concludes on the halacha is that the owner renders the collector his agent, and therefore the agent may not seize any portion of the collected item himself. The Mishnah. Ganab al pi shnayim v'tavach u'macha al pihem or al pi shnayim achirim meshalem tashlumei Bava Kamma. The Mishnah lists a series of cases in which a thief is required to pay a fourfold or fivefold penalty. If one stole an item as established based on the testimony of two witnesses, if two witnesses testified that one stole an ox or sheep, and they or two other witnesses testified that he subsequently slaughtered or sold it, he pays the fourfold or fivefold payment. Rambam say from the Zichan, Geneva 7 Mishpat 350, and he subsequently slaughtered the animal or sold it, also based on the testimony of the same witnesses, or based on the testimony of two other witnesses, he pays the fourfold or fivefold payment. If one stole an animal and sold it on Shabbat, or if he sold it for idol worship, or if he stole an animal and sold it or slaughtered it Yom Kippur, he pays the fourfold or fivefold payment, as his transaction is not punishable by death. I'm saying from the Zichan, Geneva 35 to Choshen Mishpat 250. The Mishnah is very precise in that in each case the same basic principle applied. Even if he transgressed a ritual prohibition in the court of slaughtering or stealing the animal, provided the prohibition is not severe enough to include a death penalty, he is obligated to pay for the faithful payment. Therefore, the Mishnah mentions the one who sells the animal on Shabbat. As commercial transactions on Shabbat do not render one liable to receive the death penalty. It does not mention one who slaughters on Shabbat, an act that would incur the death penalty. Likewise, the Mishnah lists selling an animal for idolatry, which is not a capital offense, but does not mention slaughtering it for idolatry, which is a capital offense. Finally, it says the case of one who slaughters the animal in Yom Kippur, is able to receive excision from the water come kite, but not the death penalty. If he stole it and sold it for idol worship, or he stole it and slaughtered it on Yom Kippur, he paid fourfold the faithful payment. Although his sale was slaughtered in the circumstances of a sin, he is not able to receive the death penalty for the sale and must constantly pay the full faithful payment. If one stole an animal of his father's and then slaughtered it or sold it, if one stole an animal from his father and slaughtered it or sold it while his father was still alive, he pays the fourfold faithful payment. Rambam say from the Zichan of Geneva to 6 towards Choshen Mishpat 250, and after his father died and he inherited his father's estate, either on his own or in partnership with his brothers, or if he stole an animal and slaughtered it after he consecrated it, he paid the fourfold faithful payment. He stole an animal and slaughtered it, and afterward he consecrated it. If one stole an animal and slaughtered it, and after consecrated it, he pays the fourfold faithful payment. Rambam say from the Zichan of Geneva 26 to Choshen Mishpat 50. In the case of one who stole an animal and slaughtered it, not for the purpose of eating its meat, but to use it for medicinal purposes. If one stole an animal and slaughtered it for medicinal purposes or to feed it to the dogs, he pays the fourfold faithful payment. Rambam say from the Zichan of Geneva 28 to 50, or to feed the meat to dogs. And likewise, the thief who slaughtered the animal to eat its meat, but was found to be an animal with the condition that would cause to die within 12 months, treifa. If one sees an animal slaughtered and found to be a treifa, he pays the fourfold faithful payment. The Rambam say from the Zichan of Geneva 28 to Choshen Mishpat 50. Rabbi Shimon consistently maintains throughout the Talmud that an act of slaughter, even if performed according to halachic standards, is not considered a slaughter for the purposes other than eating the meat of the animal, if it does not result in the meat being rendered permitted for consumption. Rabbi Shimon agrees that a valid slaughter in those cases where a thief slaughters an animal for medicinal purposes or for feeding or dogs, these acts of slaughter, albeit not intended to produce meat for human consumption, do technically permit the meat to be eaten. The use to which the meat is put after slaughter is irrelevant. Or a thief who slaughters a non-sacred animal in a temple courtyard. If one stole an animal and slaughtered it at a non-sacred animal in a temple courtyard, he pays the fourfold faithful payment. Rambam say from the Zichan of Geneva 2:8 to Choshen Mishpat 350. A non-sacred animals in the courtyard. It's permitted to bring non-sacred animals into the temple courtyard. When it slaughters non-sacred animals in the courtyard, receives lashes of rebelliousness by rabbinic law. He may not derive benefit from the animal. Most commonly agree that it is not a Torah prohibition. He pays fourfold the faithful payment. Rabbi Shimon exempts the thief from the fourfold payment in these last two cases, and he maintains that the legal status of the act of slaughter that is not fit for accomplishing its full ritual purpose is not considered an act of slaughter. Gemara. The Mishnah teaches that if two witnesses testify about the theft of an animal and two other witnesses testify about slaughter or sale, the thief pays the fourfold faithful payment. The Gemara says, let us say that the Mishnah is not in the opinion of Rabbi Akiva in his exposition of the verse based on the testimony of two witnesses, or on testimony of three witnesses shall a matter be established. Deuteronomy 19:15. The Gemara elaborates, as if it is according to the opinion of Rabbi Akiva, the thief would be exempt from the fourfold faithful payment. As the Rabbi Akiva says, the verse teaches that witnesses' testimony must refer to an entire matter and not part of a matter. In the case discussed by the Mishnah, the second set of witnesses testified that only this man slaughtered or sold ox or sheep, not that he stole it, and therefore their testimony alone will not render the thief liable to pay anything. As taught in the Tosefta Bava Batra 2:4, that Rabbi Yossi said, when Father Halafta, Rabbi Halafta was a native in the city of Tzipori, where he served as the presiding rabbi. In his youth, he saw the temple, and he knew the sages who lived in that generation. He lived a long time and studied in the yeshiva of Yavna, and was a colleague of Rabbi Akiva. Bava Kamma Daf is mentioned in the Mishnah, and the same opinions and answered those to the two appear in the various Braytot. His foremost disciple was his son, the son of Rabbi Yossi, who often cites his statements and mentions him many times, invariably referring to him reverently his father Halafta. Went on to study Torah with Rabbi Yochanan ben Nui, and some say that he said when Rabbi Yochanan ben Nui went to study Torah with his father, Rabbi Halafta, he said to him the following in the course of the discussion on halacha of possession. Thank you for listening, and wish you all the best. Bye.